I'm Gillie Hopkins. I'm the Permanency Planning Program Manager for DCF, also the manager of the Adoption Unit and the co-director of Project Family.
Hi, I'm Wanda. I'm the Director of Adoption at Lund and the co-director of Project Family and also a foster adoptive parent. We're here today to talk to you about the adoption process in the state of Vermont. And I want to give you a little history about Project Family. In 2000, the Department for Children and Families and Lund worked together on writing an adoption opportunities grant that was funded for 5 years. We created that partnership due to the lingering waiting children in the state foster care system. At the time of the grant, there were about 90 children that were waiting for permanency. And so in developing that partnership, which is a nationally recognized program, we were able to have children achieve permanency much quicker and more efficiently. And to date, we have finalized over 3,800 adoptions since the conception of Project Family.
I want to talk with you a little bit about the termination of parental rights process, which is what starts the adoption process in Vermont and actually in every state. So a termination of parental rights petition can be filed by any party of the court. It's typically the Attorney General's office representing DCF, but sometimes it's the child's attorney. Very, very rarely it could even be the parent's attorney. Once a termination of parental rights is filed, several hearings will be held, typically a status hearing. The process can be really succinct or it can be really drawn out depending on the outcome and the way that the termination of parental rights is going to be achieved. If the termination of parental rights is going to be voluntary, sometimes the process can be pretty quick. The birth parents go into court, they decide that a termination of parental rights and adoption as a permanency outcome for their children is appropriate, and they let the court know that. When that happens, the procession to adoption can be pretty fast. Very often that's not the case. Birth parents love their children and they are doing the best they can and they fight the process. When that happens, termination of parental rights proceedings can be pretty drawn out. They can last months to sometimes the entire process can take over a year. At the conclusion of a termination of parental rights proceeding, there's always a written order. If that written order comes out of a voluntary relinquishment, there's no appeal period. If the written order is a decision made by the court, the birth parents will have 30 days to consider whether or not they wish to appeal that order to the Supreme Court. If they choose to appeal the order to the Supreme Court, there's no new testimony that's needed to be given. However, that process can then take a period of time. If at the conclusion of the appeal by the Supreme Court rules that the termination of parental rights is to be upheld, DCF and Project Family can then proceed with the adoption.
Once Project Family is notified that TPR has been held and a written order has been issued, you will be receiving an intent to adopt in the mail. You will complete the intent to adopt and mail it back into the adoption administrative assistant. That will be either Matthew Cameron or Elizabeth Ching, depending upon what district office you're working with. Once they receive the intent to adopt, they will then send out a packet to you that will have a list of all of the materials that you need to collect. And the biggest thing that we will want you to do is to get your fingerprints done. Yes, you have already got your fingerprints done, hopefully, to become a licensed foster parent, but those are Adam Walsh fingerprint checks. You will have to get your fingerprints done again for adoption. So every foster parent has to have their fingerprints done twice. In order for us to be able to finalize your adoption. Once the fingerprints are done, your packet is submitted back in, and we receive your packet, we will then schedule a meeting to come out to your house. At that first meeting, we will talk to you about how things are going with your child. What are your child's unique and special needs? How's your child adjusting to home? How are things going at school? Is your child on an IEP? Is there any medical issues that are going on for the child? Do you have a team of people that are working with your child? Oftentimes, if your child is having a higher level of care, and there's a team of people, a therapist, school personnel on an IEP, we will have a treatment team meeting. Because one of the things that we want to make sure happens is that children have a seamless service of care. And so once an adoption happens, the family, you, are in charge of what happens for your child and making sure that their needs are being met. Because when the child's in custody, your DCF social worker signs off on things and agrees and approves of services and supports for your family. Once we also may talk to you about if you have agreed on any kind of birth parent contact and what that might look like, and we talk about those things. We complete all of the necessary paperwork for your adoption assistance agreement, and then we submit that agreement into Gillie at DCF.
The state of Vermont provides adoption assistance to all children who are adopted out of the foster care system with special needs. The determination of special needs is pretty much achieved for all children who have been in foster care. Once we determine the special needs of your particular child, we can think about what sort of assistance your child will receive until 18 and sometimes even beyond. All children adopted from foster care in Vermont receive Medicaid up until the age of 18. Some children receive Medicaid beyond 18. If your child is a child who would be eligible to receive Medicaid beyond age 18, we'll review that, or the Economic Services Division and Health Access will review that somewhere between 6 and 8 months prior to your child's 18th birthday. Some adoption assistance agreements also come with cash support. Now, it's very important to remember when you receive an adoption assistance agreement that any cash support is to meet the special needs of your child. When you adopt a child from foster care, you assume the parental rights for that child. You agree when you adopt that child that you are going to financially meet all of their basic needs. Any financial support offered through an adoption assistance agreement is solely to meet the special needs of the child. We determine the amount of the assistance agreement based on the special needs of that child, and the amount can never exceed what the child would have received had they remained in foster care. Ultimately, your assistance agreement is sent to us by your Project Family worker, and then we at the adoption unit review it. I review it, and then there's a system of checks and balances, and your agreement is signed finally by the Deputy Commissioner for Family Services at DCF. All this talk about special needs, it might be helpful for you to have a few examples. A special need of a child is a need which results from either the trauma or the medical needs of that child, sometimes having to do with some hereditary factors. An example of a special need would be therapeutic horseback riding. An example of a routine need of your child would be something like school pictures or funding for school dances. If DCF is able to offer cash support to meet the special needs of your child, that's precisely what that funding is intended to meet.
Once the signed agreement comes back from the Deputy Commissioner, we will schedule a second meeting to come out to your home. At that meeting, we're going to sit down with you and review the signed adoption agreement that has been written for your child's unique and special needs. And we will complete all of the other paperwork that is required for your adoption finalization packet. It's also during that time that we will interview you to get the rest of the information that we need in order to complete your finalization report that is then submitted into the probate court. We will spend some time with you and your child and the other children in your home talking to them about what the court process is going to look like. Each probate court, where we finalize the adoption, hold their court hearings very differently. And if a child has been to the family court and been a part of a permanency hearing, things can get scary. So we like to talk to kids about what that process looks like and what they can expect. What you should know is that finalization hearing is your hearing as a family. The only people that are mandated to attend that hearing are your project family worker, yourselves, and the child. You are then able to invite anybody that you want to invite. Some families have a private hearing with just the immediate family, and other people invite 40 people to attend the hearing. Your DCF worker is not a invited member to attend your hearing. If you want your DCF social worker to attend the hearing, you need to call and invite them yourself. Also, guardian ad litems oftentimes like to go to hearings, but they're not allowed to go to hearings. So unlike the family court process where you get invited to attend, this is where you get to have the opportunity to do the inviting. It's really about a celebration for you and your family.
So that finalization hearing is really the beginning of your journey parenting your child. It's a celebration that you're now the legal parent of your child, and DCF and the family court are no longer involved. The process that Wanda and I have talked about is the process of adopting a child who is in DCF custody out of the foster care system. You may be sitting watching this thinking, I'm a conditional custodian. If you have conditional custody of a child with family court oversight, there are a few differences. Overall, the process is largely similar. However, there are 3 major differences. The first difference is that you're likely not a licensed foster parent. So when Project Family comes to meet with you, they will be meeting with you and you'll be filling out that paperwork and completing a set of fingerprints for the first time. The second difference is that your subsidy that DCF is able to offer you isn't as easily able to be calculated. The subsidy can be anything from 0 to any support that you're currently receiving through the Economic Services Division to what DCF believes we would have been paying in foster care, but it's much harder to calculate. It is still based on the special needs of your child. Any adoption assistance agreement is based solely on meeting the special needs of a child. The final difference between an adoption with a child in DCF custody and an adoption of a child who you're already the conditional custodian of is that the termination of parental rights is issued with residual rights directly to the conditional custodian. So rather than DCF receiving residual rights of that child and custody of the child, you end the TPR hearing with custody of that child. So there's therefore no intent to adopt that needs to be signed. Instead, the social worker or you need to reach out to Project Family to start the adoption process.
Another area that we talk about during the process to complete the documents for your finalization is your entitlement to be able to receive post-permanency services. And if that's a service that you would like to receive, then our Project Family workers will make a referral to the post-adoption agency that covers your district, and we will schedule a time for that worker to come out with a Project Family worker to your house so that you're not having to tell your story all over again, but it really tries to help with that sort of seamless service. One of the really wonderful things about post-permanency services is that the workers are trained very specifically about the needs of adoptive families and adopted children, so that they can come in and be really strong advocates and voices for you. So lots of times families can say, boy, my life seems so much easier now that I have a post-permanency person that comes in to meet with me on a monthly basis because they know what we need. They're there to hear what our children need for services, and that they also help us to advocate for our children and the needs that our children have, and they're well versed in adoption. One of the other important messages that we at Project Family want to make sure that families know is that it takes a village to raise a child, and that we're going to be here from a day to a lifetime. When we developed Project Family back in 2000, we did develop a tagline, and that tagline was giving a child with a challenge a chance. and that the Department for Children and Families and Project Family are supportive in that, and that we're going to be able to be there. And we know that the best time to access post-permanency services is right at the beginning, because sometimes it's really hard for families to call, but it's okay. It's okay to reach out for help, whether it's immediately after your adoption, before your adoption is finalized, or 2 years down the road. There will be a time that you need some help, and we're going to be able to be there to help you and support you and your family.
Part of the termination of parental rights proceedings, when the relinquishment of a child is to be voluntary by the birth parents, could be discussion of a post-adoption contact agreement. Post-adoption contact agreements are a relatively new addition to Vermont adoption law. If a post-adoption contact agreement is being considered in the case of your child, one or both of the child's birth parents may choose to voluntarily relinquish and include a post-adoption contact agreement as part of that relinquishment process. A post-adoption contact agreement proposes that some level of contact continue between the adoptive child and the birth parent. Post-adoption contact agreements are voluntary and can be negotiated for each birth parent. They have to be agreed upon by all parties to the court. The division needs to agree, DCF. The prospective adoptive parents need to agree to the contact terms, as well as the birth parent. The negotiations occur with the support of Project Family. If a post-adoption contact agreement is being discussed in your child's case, please let your DCF social worker know, or if you're already working with Project Family, let your Project Family worker know that you'd like to discuss specifics.
If a decision is made for a post-adoption contact agreement to be negotiated, what you should know as a foster parent is that that negotiation should be happening with somebody that is not a party to the case. So your Project Family worker, someone from Lund's adoption department, can work with you and the potential, or can work with you and the birth parent or birth parents to talk about what everybody would like to see in a post-adoption contact agreement. The agreements can be different for each parent, and it needs to be what you as a foster adoptive parent feel like you can do today, tomorrow, and 10 years from now, 15 years from now, because these agreements are until the child reaches the age of 18. And we can be very specific around what those agreements look like, what's going to happen, and we're able to help negotiate what's the best agreement for your child. And remember, the post-adoption contact agreements are supposed to be looking at the best needs of the child. It's not a faster way to get to a termination of parental rights. It's not a point of you feeling pressured to be making a decision. Also, the post-adoption contact agreements should not be agreements that are done in the middle of a court hearing. So if you're at the termination of parental rights hearing for your child and somebody brings up the fact that they would be willing to enter into a voluntary agreement, doing a post-adoption contact agreement, you can very clearly say to that child's attorney that you're not in a position without being able to negotiate with somebody that's not a party to the case in the courtroom to be able to negotiate that agreement. And it's okay for you to do that. And while I understand that court hearings are taking a very long time to be heard, that it's very important that any agreement that you're agreeing to is an agreement that you're going to feel comfortable with today, tomorrow, and into the future.